You may proceed with your argument, sir.
Thank you, Your Honor. So I'd like to ask the court to take into consideration all 9 years of positive reviews. I never had any disciplinary issues in the past, and 5 months do not represent my my career. So and concerning the discrimination part of my case, I was under the impression that that part should be handled by the federal court. So that's why I didn't emphasize that during my hearings with the board. And again, there are some other clerical mistakes on the board decision. Like I never worked for the corrections. For example, I transferred to the state of Florida not shortly after that incident, and again, I never had disciplinary issues before and after these 5 months. And again, I would like to review that to protect others in the future, because what happened to me shouldn't happen to anybody else. I strongly believe that my termination was fabricated by unethical managers without the best of intentions. And again, it was discriminatory because there was no compatible conduct. The entire process was biased and unprecedented and discriminatory in nature. It was based on falsehood hearsay in a smear campaign. Ms. Roya was my supervisor in the same division for approximately 7 months, and she highlighted among other qualities my excellent attention to detail. Nothing changes in 5 months so fast. That's what I would like you to please review this case. My supervisor, Ms. Lewis, from the beginning of the pandemic in March until December, acknowledged that this satisfactory review was never discussed with me. I never discussed until to date with her that satisfactory review. That was triggered my rebuttal and my grievance with the union, and all that happened between February of 2001 until my termination in September, October. So 5 months. The evaluations that they gave to me was fabricated prior to be given to me only. Nobody else was given that evaluation. I know the state has 8,000 people working for the state. They never used that with anybody else. That was totally discriminatory. The UC filed, charged them in August, after I sent all the emails and everything with the union, that I was back and forth with the union. I sent them all the information. They talked to me on the phone for several hours, and they decided to charge them in August. They gave me a letter, right to sue letter, that expired in February. Was in Florida. I didn't pursue that in the federal court. So so basically, my case is about not being treated fairly, being discriminated against, and a smear campaign against me. In only 5 months, I became the worst employee in the state of Vermont, which is not true. And even Ms. Struder acknowledged that I was the first one to take the performance assessments. In the first minute of the assessment, she agreed she acknowledged that. Also, Ms. Lewis lied on the oath that she worked for Program Technician 2 for 3 years, which is not true. It's a new position. She didn't do this job before. This position was created uniting 2 tasks. One is the operational, and the other one is the grants. She was working only under the operational part. So basically, it was not true that she worked 3 years and a half as a Program Technician 2. So as you can see, Your Honor, the case has several inconsistencies. It's not based on the truth. I was discriminated against. It's not easy to say that I was discriminated against because I was born in Brazil, but I was definitely discriminated against in the process overall. And they knew that I was born there because, probably I have an accent, and my name is Spanish. There's several other characteristics that indicate that I wasn't born here. I'm a citizen, but I wasn't born here. So I believe I can continue here without examples.
Well, your time has expired, sir, so you're going to have to leave it there.
Okay.
All right. And now, counsel for the appellee, please introduce yourself and your client, and you may proceed.
Thank you, Your Honor.
Thank you, sir.
Ryan Kane on behalf of the state.
Cannot hear you, Mr. Kane.
Not hear me. Earlier.
Can you hear me now?
That's better.
Sorry about that. Good morning, Your Honors, and may it please the court. Ryan Kane on behalf of the state of Vermont. The sole issue that is probably before the court is Mr. Gelio's motion more properly.
It's no longer better, Mr. Kane. Please hold up his time till we get this figured out.
Can you hear me?
We could for a moment.
Okay.
Mr. Gelio, would you mind muting your microphone?
Sure.
How about now?
Not very good.
Last try. Can you hear me?
Yes, if you speak slowly so that we can hear it. Yes,
Okay. Still with me?
just about.
Okay. I will speak slowly and loudly. Thank you, Your Honor. The sole issue that's properly before the court is Mr. Gelio's motion to reconsider, which the board properly treated as a motion under Vermont Rule of Civil Procedure 60. And it did so because that was the only motion that could have timely been filed after the board's decision. Under Rule 59, motions to alter or amend must be filed within 28 days from the entry of judgment. And so the board properly concluded that Mr. Gelio's motion that was filed 30 days after the board's decision was not timely. Importantly, Appellate Rule 4 only tolls the appeal deadline for a timely filed Rule 59 motion or a Rule 60 motion if it was filed within the same time frame as that required under Rule 59, which is 28 days from the entry of the order. So the board did not abuse its discretion and properly concluded under the law that the only available avenue for relief to Mr. Gelio for his motion to reconsider was under Rule 60. Rule 60 motions are reviewed by this court for abuse of discretion, and the board's decision clearly indicates that the board did not abuse its discretion in denying Mr. Gelio's Rule 60 motion. That motion re-argued facts and positions that were fully presented and considered by the board over 4 days of hearing in the underlying matter, and that's simply not a grounds to reconsider a judgment. The court has no further questions. The decision of the Labor Relations Board should be affirmed. Thank you.
All right, seeing no one with questions, the bailiff may call the conclusion of this case.